So I would like to tell you about Kevin Day coming from a personal standpoint, because I am about life. From a personal standpoint, I met Kevin Day many, many years ago, and I was in a completely different world. And from the very beginning, what I noticed about Kevin Day is his intellect. He is a frickin' brilliant human, and which I admire and I appreciate, and it's super fun for me to be around really smart people so I can learn from them. But the number one quality that I esteem, the highest esteem that I have, the number one quality is kindness. And Kevin Day has intelligence. He has experience that I can't even imagine, the things that he's seen and the people that have been protected and the empires that have been structured properly that we will never know about, because that's how they're made. They're made to be private. And he, amongst many other things, 2 beautiful children, a loving wife, and a life that is gorgeous. It is my pleasure to introduce to you a brilliant attorney, a genuinely good human, and my friend, Kevin Day. Please welcome him warmly to this stage. Kevin Day, the time is now yours.
Oh my, that's recorded, right? Can we send that to my family? That is lovely. Thank you so much. Okay, so the topic today is really what it says up there. Making money is only good if you're able to keep it, and that's not the most fun part about being an entrepreneur. As an entrepreneur, you want to get out there and get the next customer, you want to buy the next property, you want to build another company that's doing something that's generating money, and so what I'm offering and what my firm does is the stuff that's not so fun, but you really need to do it, and that's the lawsuit protection. Today, we're really going to focus on trust, so we can educate you on the differentiations, on the 3 primary types of trusts out there in a big, broad scheme that relates to this area. As Ben Golden said the other day, is there a silver bullet? There is, and that's the irrevocable versions. So we're going to talk about the domestic asset protection trust, which is in the normal Rockefeller package, but we're also going to educate you about offshore trusts. Now, the offshore trusts are not inexpensive. There isn't anything negative. Everything is good about them except for the price tag. And so it's not going to be for everyone, but it's kind of sexy stuff, so it's fun to learn. And your job is to grow to that point when, that guy at Laughlin that lectured about that offshore trust, it's been 5-6 years, but now I'm ready for that. And we can do provisions that allow it to decant and not start a new statute of limitations. And we'll talk about fraudulent conveyance in more detail so you know what that is. That's relevant whether you just have a little Rockefeller company or you have a Rockefeller company with a domestic trust. It's really important for you to know what those lines are. So this is the traditional old-fashioned trust that goes back to the Crusades, when the settlers, as you learned yesterday, are, let's say, you, and you set it up and name your sister-in-law as trustee, and your kids are the beneficiary. And that's good planning, especially if your estate is starting to get larger, to make completed gifts to your children of something that you're buying that's going to appreciate a lot, because you don't want to get out of the gift tax, you want to get out of the gift tax problem if you know a company is going to grow exponentially, or a property is a super deal and you know it's going to appreciate. Why not put it in the mechanism that the kids technically own it now, but we can give you back and in the provision so that you control it? That's what Sam Walton did with Walmart. He had a limited partnership and a privacy company like a Rockefeller, gifted it into this kind of trust for the children, made billions of dollars, and when he died, there wasn't any tax to them, There wasn't any gift tax out of the estate because they had already owned it from the very beginning. He merely controlled it. He was able to pay for his lifestyle extravagantly, but a lot of law changes happened after that because Uncle Sam wasn't happy that so many billions, they didn't get a bite of the apple because he did proper planning beforehand. Now, this is an example of the revocable living trust. You are the settlers. This is a picture. Whoa, let's go back. This is a picture of you at the moment. And you're the settlers, and you set it up, but you sign with your hat on as the settler. I'm setting this up, and who am I naming as the beneficiary? You change hats. I'm going to name me, and I'm going to be the beneficiary, but I'm also going to be the trustee. So there's several reasons why these are not lawsuit-proof. Yesterday we talked about irrevocability. It's revocable. This is changeable. And the court will say, hey, it's changeable. Get it back to yourself so you can give it to the creditors. But independent of that, you could, if you had an irrevocable trust, but named your sister-in-law, Sally, as the trustee, and you named your children, so you're not a trustee or a beneficiary, but you can still revoke it, then it unwinds it. But the two types of ownership that we split have been merged back together in that document. So there's multiple reasons and different configurations, and you still don't have a trust that's lawsuit proof. But it's really important because it avoids probate. And and I'm going to we've got a lot of material to cover in 1 hour, so I'm going to be rushing. Take pictures. And also the video will be made available to all of you, so you can do it that way too, but go ahead and take pictures. Probate, let's say these are out of the probate code, California Probate Code 10,800 et sec. It starts at 6%. The trustee it used to be called an executor if they were male, executrix if it was female, and now we call them personal representatives, but many of your states still use executor, executrix. That's the person that the court will finally, after usually around, how many of you been through a probate? How long did it take?
3.5 years.
3.5 years. Anybody else? How long?
Almost 4.
4 years. And those can be simple estates. Somebody, like Prince or people that have large amounts of estate and you're reading about it in the paper, you can read in the paper who the beneficiaries are and what's happening, and it's taking 10, 15 years. It's all in the public record because they're in probate. You get zero privacy. Where did I put privacy? Yeah. There's no privacy in a probate because it's like any other court case in the United States. And you can go into a probate court and go up to the clerk. You'll see a bunch of picnic tables with people scribing away, and then they take that file up, give it to the clerk, get another file, scribe away. What do you think those people are doing? Any guesses? They're mining. Because the will, if there is one, and if there isn't a will, still goes through probate. And let's say there is a will, or even if there isn't a will, then there's a court formula of how people inherit. And they're looking, Billy gets the cabin up in Breckenridge, Colorado. Sally gets this house. They're both going to split the company. They get a template. They're getting a treasure map right there. And if Billy drives a Volkswagen and he only owns his college, dorm furniture, and somebody says, hey, we'll buy that Breckenridge cabin for $300,000 right now. We can give you cash tomorrow, and you give us an assignment, and you don't have to wait the 2 to 4 years to get it. Billy might say yes, because they're emotionally unstable because a loved one just died, and they don't know the value of things yet, and they're really disoriented, and they, older people. My mom, when my dad died, he was a sixth grade school teacher, as I said. They only published his death in the little local paper, which, I mean, the town is only 28 or 29 streets long and maybe 4 or 5 deep. And my mom got a call, not at dinner time, but at 2 and 3 in the morning, of people saying somebody took the time to take that obituary and look for where Robert Day was trustee of a trust, and there were 3 properties. So my mom gets a call, "Oh, we're so sorry about the death in your family, and I know that this is going to be a financially really hard time. We can come and buy these properties, tomorrow." My mom, who's now 96, still living at home, for her 85th birthday, she went hang gliding. She's a pip. These people got an earful. What shocked me was that they called 2 o'clock in the morning. It took me a couple years to just think about it. And finally I realized these predators realize the family go back to the hotels and everything, probably 10 o'clock at night, maybe 11, and my mom is still up crying her eyeballs out. Right? So they knew she was going to be awake and vulnerable. So you get no privacy, but with a living trust, any trust, you're going to get privacy because it's not going to be in the public record. We had a client today saying, "Oh, I was just told that someone in their sphere died, and we were told we couldn't make a distribution." And I thought, we have a living trust. We can go ahead and make distributions. You can still do activity. You can still buy and sell. You can prep homes, but you can't make distributions for 120 days. There has to be notice out to all the immediate heirs, whether they're included in the trust as beneficiaries or not. And usually everybody is. You have to have a misfit child, and we all have families that have one of those misfit childs that might be disinherited or have more restrictions on other things. But even if everybody's equal shares and they're old enough to get full distributions, they still have to be technically noticed before you can make distributions. So the whole point of probate is to get the word out so that some cousin back in Pennsylvania can come out to California and say, "Here's the letter that my aunt, Tony, and Uncle Robert said that I was going to get some property. Here's the letter. I have kind of a contract. So even I was omitted and I have a right." And even just anger between, we have a litigation department, we have, 5 litigators or something like that. And people fight in families because they have time. They're all crying on everybody's shoulder for a year, but then they kind of sober up, and then they're dealing, with getting things done through probate, through lawyers. And somebody says, "Mom promised me the dining set." And as soon as one flag is planted, everybody starts planting flags. And then it's a horrible process. So I personally believe, this isn't legal, but I personally believe the faster you can get it done while everybody's still crying on everybody's shoulders, then they can horse trade later. But the faster you can do it, the better. Let's see. Oh, and the last one, lawsuit protection. No, we already talked about why. Everybody has heard that, if my estate is small enough, I have a short way to get through probate, and that is correct. But if you look at the fair market value thresholds, they're really, really low. Even in the high states, aren't very high. And so if and remember, fair market value versus your equity. So if you have a home that's worth $500,000, but you only have $100,000 worth of equity, in most of these states, including California, you're going to lose. That's all you have. You have this home, let's say it's worth $900,000. Some attorney and we're always encouraged, don't just do a will, do a trust. Spend $3,000 now, because otherwise your family's going to come to us and we're going to do a probate and we're going to get $35,000 that should have been going to your heirs. So even though you don't like contemplating your death, it's a hassle, you don't want to spend $3,000, it's absolutely worth it. Now this is the trust configuration, using the same slides, of how the lawsuit protection trusts work. And as we said yesterday, these did not exist in the United States until 1987, when we signed the Hague Convention on Trusts. And that law says that you can set up a trust in other countries, and that law prevails. That law will be the law of the land here in the United States. So it effectively removes U.S. court jurisdiction if you're using one of these offshore trusts. And so you're the settlor, you can't be the trustee, but you can be the beneficiary. That's the cat's meow, because it's all about you, it's for you. And just like my first lawsuit protection trust that I drafted for me, I wasn't married yet, so it was for me, children if any, spouse if any. And then as soon as I had a spouse, she was included. I haven't traded in spouses, but I could have a divorce and the new spouse, because the spouse is a legal term of art. It's whoever is making me happy at the end of the day. So these kind of trusts are actually lawsuit proof if it's pre-marriage planning. If you're already married, you've got the law of the land, both of you are going to set up the trust, both of you are going to be clients, we're going to be treating you the same, the trustees are going to be treating you the same. But if you have an empire, or you're building an empire, and you've been hesitant about getting married, you can do this, unlike, and we do, premarital agreements, but premarital agreements are always challenged in court, just like in the movies, they actually are, because a contract, a trust is a contract. Remember, you learned that yesterday. A contract is a thing of law. Family court is not a court of law. It's a court of equity, which means whatever the judge thinks is fair. So if it's an acrimonious divorce, they say, hey, we both had lawyers, it was fairly argued and everything, and they'll say, great, give it to us, we'll read it, and we'll take it under advisement. And that's why 1 in 4 premaritals are not supported by the court, and it's divided differently. But even family court will not mess with the concept of ownership. So if you changed ownership into an irrevocable trust and you're not the owner of the empire and the properties, and then you get married, there are going to be some rights that, to salary and these other things, but it's divorce proof, and you don't have to have the spouse that you're marrying sign off on anything, and you don't have to do disclosures, and it works. We're not encouraging divorce, but as a lawyer, and I'm educating you, that's an advantage to some people. But in what happened, and I think I have a slide. Yeah, so this is the foundation. I just wanted to hit home the same slide yesterday, that we've got personal liability, which is an external attack out from the world, and then we've got that internal liability. So that foundation of lawsuit protection is companies. You do want to put eggs in different baskets, but you don't have to get wild about it. The typical one is, oh, you need an LLC for every every property you own. We usually will put 4, maybe even 5 in one LLC, because the equity stripping of Rockefeller's strategy is the real lawsuit protection. It's just smart to get it away from your home, which is your castle, and from your savings accounts. Everybody got this yesterday, the difference between, anybody didn't get it, I should ask. Okay. A quick rehash, this is what you have. You have your operating company, you've got your rentals, the rentals have tenants, your operating company has employees, customers, products, and services that can all bring liability. So we leave that in your name. We leave that on your side. You're a lightning rod anyway. As we heard yesterday, any good lawyer is going to find any way, even if it's pretty remote, to name you personally, because the extortion or blackmail, it's actually extortion, process of the lawsuit is to make you feel that you are going to lose everything, so you sell something, you put something else on the table for settlement. And so the very first thing we're going to do is we're going to take the liquid assets, in red, and we're going to move them over to your Rockefeller company, because the cash and portfolio and notes, that's the low-hanging fruit. They don't have liability. What does the plaintiff's lawyer want to do for their customer, their client? They want to make sure that they don't have any liability. Taking real property or taking your business, oh, we had to sue them. There's probably all kinds of other liability lurking out there. Everybody goes, oh man, got sued, I got this judgment against me. They finally got my property or my business and they sold it for half the value. They're trying to screw me more. No, they want every dime, but they need to get it off their plate, because now they're the owner of that company and they can get sued for something that company did when they didn't own it. So they want to fire sale it, and we want to get the low-hanging fruit out, because that helps settlement. That's the first thing we're going to do. The next thing, so the little red dotted lines are that equity stripping strategy. So if we took it to the nth degree, the right side in this diagram, the lawsuit-proof trust and the Rockefeller, literally owns everything. It technically owns in its own name all the good low liability or zero liability assets, and it's equity stripped, so it effectively owns the equity in your high liability world. It would own everything, so we truly make you a turnip. This is a diagram of actually the paperwork that we do to make this work. You need a deed of trust against real property, either in the form of a mortgage or a deed of trust, depending on your state. They're the same thing, really. UCC ones are for all personal property. So UCC ones can encumber your machinery, your cars, your accounts receivable. So that is a uniform commercial code form number 1, which is, those are the 2 liens. Liens against real property, and then UCC ones for personal property. This is the only strategy. Laughlin's strategy with Rockefeller is the only strategy that we know that is one item that can protect your personal property and your business property. All the other asset protection forms are either structuring just to protect your home and your personal savings, or you're structuring to do business. And this is one bird that is doing both, or one stone that's hitting 2 birds. I got that mixed up. Haven't had my second cup of coffee yet. But having that paperwork, we talked about yesterday, the proper consideration, which is a legal term, that there was something of proper value. And as we talked about yesterday, intellectual property is wonderful because it's subjective. We can make, a marketing piece or a list of customers or a procedure worth a lot more than $1 for $1. If most of entrepreneurs are smart enough that your money is leveraged. We've had people, come. I had this guy that had 147 apartment buildings. He was very wealthy, obviously. His net worth was incredible. He only had a liquid account of about $200,000. How am I going to encumber these millions and millions? A line of credit is very simple, and then you borrow very little, so we at least have one transaction, that $5,000 against a line of credit for several million. We post in the public record the several million, and then you don't have to worry about, making interest payments and all that, and we can get a very high level of lien power. Okay, home state, and your Nevada Rockefeller. Promissory notes, security agreements, licensing, installment sales. These are the things that if we had to go to court and defend it as legitimate structure that the court has to respect, that's what's in the paperwork aspect, which some of you won't need in your structure. Some of you will. Some of you, just the Rockefeller and changing ownership is sufficient. And that's why you want to do the individual meetings. You saw this yesterday. Get you away from the world. You're operating in the world. You're operating cars. You're shaking hands with people. You're making deals. You're going to be a lightning rod. That's part of not just, you're all entrepreneurs. So you've ratcheted it up. You're not just a normal citizen out there. Domestic Asset Protection Trust, I told you in 1987 we signed the Hague Convention on Trusts, and that was the first time we could create one of those trusts that named you as a beneficiary of a trust. You couldn't do that before 1987 and have it be lawsuit proof. 10 years later, the state of Alaska passed a copycat law. And I got interviewed by the National Law Journal saying, hey, Kevin Day, Mr. Expert, what do you think of this, blah, 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 blah. And I said, it's going to be great if you're an Alaskan being sued by an Alaskan. If you live in Texas and you're being sued by somebody in Arizona, they're not going to give a rip. And I kind of was very standoffish about these until I had this guy. He was starting 3 restaurants at once. He had been to one of my lectures, and he said, okay, we haven't talked about fraudulent conveyance yet, but we will right after this. He said, I got your point on the fraudulent conveyance, and so I'm opening these 3 restaurants. I don't have any employees yet. I haven't served anybody, something bad that could go wrong, like a coli, one bad evening. I can't buy enough insurance for that. The machinery hasn't burnt anybody cook's hands yet. So it's impossible for me to be accused of fraudulent conveyance and have it stick, because I don't have any of those creditors yet. I haven't signed any contracts with anybody yet. So I want to set it up now. I said, and he was a wealthy person. I said, offshore trust is the proper vehicle for you. And he said, well, I'm kind of illiquid right now because I'm buying all these kitchens and tables and all this stuff. I said, there's these things, I really don't like them. They're domestic version of them. And but there hadn't been any case law attacking them yet. And under fair faith and credit at the U.S. constitutional level, you, just like you can set up companies in Delaware, South Dakota, or Minnesota, even though you live in California, you can set up trusts in other states, and the law supports it until it gets challenged at the Supreme Court level. So there are no tests, so it's technically legal. Let's form that and put provisions in it that, and at that time we actually put a date certain, that within 1 year this is going to move offshore. And he said, great, I'll have plenty of money by then. And then a light went on. These things they're normally $10,000. We do it for $8,000 for Laughlin clients. That is cheap insurance. Insurance always bites back. If you've ever made a claim on insurance, what do they say? Oh, we're going to send it to legal. What does that mean? The lawyers are looking at why they don't have to make a payment to you, right? They become an adversary that moment. And this is taking, even though $8,000 is a big check to write, but it's cheap insurance to get real lawsuit protection that doesn't have any exclusions in it. It works, it's a separate legal owner under the law, and it's very powerful. And so then I'm going, there's these people with little coffee carts. They can't buy enough insurance for one bad afternoon. of a coli or something, and I need to get familiar with these. And by that time, we had 3 states that had copied the Alaskan law. Now we have 15 states. Only 8 of them, in our opinion, have any teeth to them. Most of them have, I've got to talk about fraudulent conveyance, most of them have a 4-year statute of limitations on attacking them. Nevada has a 2-year. Why on earth would I select, even if I lived in a state that had the statute, why would I pick a 4-year statute like Florida when I can pick a 2-year statute of Nevada? So fraudulent conveyance, since we've kind of talked all on the outside of it, fraudulent conveyance is the only way to unravel an irrevocable trust, domestically or internationally. And so fraudulent conveyance has these statute of limitations, but fraudulent conveyance is when you transfer out of your ownership, because remember, lawsuit protection is all about ownership. If you own something, somebody else can take it through the courts. If you don't own it, they can't. Even if we're friends, we went through college together, and her car blows up, I buy her a car. She's living, what state do you live in? Oh, you don't count. Was it? So she lives in, I'm going to pick, well, that's too far away, but in upstate New York. And so I go down, pick a car, I'll buy it, get the manager on the phone, I deal with it, and she drives it for 3 years. She even pays insurance on it. I've never even seen it. I don't know what color it is. If she gets a lawsuit, can they take that car? No, because my name, Kevin Day, is on the pink slip. It has nothing to do with use and control. It has to do with ownership. And so if you change ownership and you have a known existing current creditor, not something dangerous. One of our clients is one of the 3 large fireworks manufacturers in the United States. If something blew up in the factory, he would have a lot of souls on his hands. And he got to us through his CPA, and he says, well, but I've got all this liability. I can't set that up. Has a plant blown up yet? No. So we can take your home and your savings and get that out of your name. So if something horrific does happen, you'll lose stuff that's related to that. You'll lose your property. But your main lifestyle won't change that much. So having a dangerous or high liability business doesn't mean that you can't do planning. You absolutely can, because you haven't harmed somebody. Now, the gray area on fraudulent conveyance is if you've already signed contracts with people, there's been no harm, then you set up the structure. If those people sue you, they're always going to use fraudulent conveyance, because there's no other way to bust this. If they were lucky enough to know about it, they're going to have to allege fraudulent conveyance, and they're going to try to prove, no, when they signed the contract, they were really trying to defraud me. Remember, fraud isn't covered by insurance. It's always an exception. That puts more pressure. That's the whole extortion process. But they're inexpensive. You have a 2-year statute of limitations if we're using Nevada. We use other states for particular reasons. We've dealt with a lot of other states. But Nevada is always our top, because why would you let somebody attack it in 4 years when you can do 2? And like yesterday, whipped cream on top of the cake is that you have judges that use these structures and are seeing these structures all the time. And they're supporting privacy and lawsuit protection. Why offshore? Okay, offshore is, other than that cost, and we're talking about $25,000, $28,000, so that's the number. We have them all the way up to $48,000. Our least expensive is $19,000, but usually around $25,000, $28,000 is going to be a good, solid jurisdiction, a super deep pocket trustee, even though we're making it a dormant trust. We're not opening offshore bank accounts. We're not exporting assets. You can do that if some horrible thing blows up, but what we're doing is importing foreign law under U.S. law. And what that does is remove U.S. court jurisdiction under U.S. law. So if somebody wants to attack it, they have to go to Montserrat, they have to go to Barbados, they have to go to Cook Islands, Isle of Man, wherever we put it. It is what people know, and lawyers know, that municipal law is superseded by state law, that's superseded by federal law, and then what's next? U.S. Constitution, right? No. Superior to federal law is presidential decrees, treaties between countries, and conventions between countries. And so it's superior to federal law. That's why the IRS said, well, dang, it's legal for them to do this. Our hands are tied for them to do it, but we can neuter it tax-wise. There are some international tax strategies, very few left, but there are some to have a CFC with non-subpart F income that you report and don't pay until you repatriate it, but most people aren't in the circumstances to do such things. But what our job is to keep the money that we're working for. You file 3520 that says, yep, Uncle Sam, you are saying that this is an irrevocable and therefore lawsuit-proof trust, and I promise to pay taxes on it as if it was me, unless there's some other legal way not to. And it's very powerful. As we said yesterday, judges are as afraid of the IRS as we are. It's a great document. It puts a nail in the coffin. It's recognized in all 50 states instead of just having these 8 states, 15 technically, that have these copycat laws. Now, the domestic is still really powerful. There have been some challenges, but they've not gone up. They've always resulted in settlement. Something has to go all the way to Supreme Court. What does that mean? There has to be millions of dollars at stake in the lawsuit. There has to be millions of dollars in the structure. And those people with that many millions have offshore trusts. So I think these domestic trusts are safe and going to be around for a long time. The other thing is that we put these provisions to allow it to decant or move. If you're saying, ultimately, that's my goal, and I think that my trajectory, I'm already at 300,000 or $3 million. Say, if you're $2 million and below, it's a domestic trust. If you're $4 million and above, you should really, really consider offshore. The problem is that area if you're between that 2 million and 4 million, and that's where time with me and education, we've got a white paper, email me and I'll send you the white paper. Adam, you should have that in your inbox, by the way, is an explanation of how these offshore trusts and the domestic ones work. It was written for an actual physician, a client of ours. She was a physician. She was an obstetrician, and the nature of that business is you are going to get, it's an emotional area, something goes wrong. So obstetricians get 7 or 8 lawsuits or threats of lawsuits every year. And so her configuration is a little bit different. We moved all of her real property over to the asset protection trust side because she wanted to go to deposition and say, I own my home, my car, and my practice, period. Do you own any other properties? No, I don't. Even though she already had 7, she has about 125 doors now. But that's over on the Rockefeller side, not on her side. So she wanted that to be invisible. And her home and her accounts receivable and her car all had liens on it. So that's her configuration. We pulled her personal data out, so there's a couple of non sequiturs, but all the juice about how these work, and not in legalese. It's easy, 8 pages to read or 10 pages to read. So if you want that, just email info@trustday.com or trustday.com and we'll get that to you. Let's see, just for the fun of it, the sexy stuff, these are the jurisdictions we use. I like Cook Island and the Isle of Man the most. Cook Islands is kind of the cat's meow because as soon as the Hague Convention was passed, they went and they reached out to everybody. I was one of those attorneys that they reached out to, and they said, hey, can you add any provisions? Is there any concerns how we can make this the best law? Because trusts are still estate planning. That's what they were all about, estate planning. They just happened to have this side effect of lawsuit protection. Their statutes turned it around. It's all about lawsuit protection, and it also is an estate plan. And they got about an 8-year lead on asset protection work out of Europe and America before any other states really got into it. They've had some big cases that have come where people have decided to go there, and some have gone after the 2-year statute of limitations, complete bar. Some have actually paid the cash bonds, $150,000 or whatever, to run the case within the first 2 years, and the law's been wonderful, and it works fantastically. So, and they have enough American clients that they come here periodically, so you're not just relying, hey, is Kevin as smart as they say he is? Is he ethical? Is he going to get me in any trouble? Is he leading me down the wrong path here? Is it legally compliant? And I hope those trustees that he said has hundreds of millions of dollars in actually check writing authority over trusts, is this real? But when they come here, they actually come here to talk to CPAs and lawyers that refer to them. We demand, don't call us, call the clients in the area, and they'll say, hey, we're sweeping the United States, we're going to be in New York, we're coming to Pittsburgh, we're going to go to San Francisco, we're going to go to Chicago and San Diego. And they'll have coffee, lunch, dinner with you, so you start to realize, they're a barrister or a solicitor, which is an attorney in, let's say, the Cook Islands, and there's 3 other attorneys that all, in triangulation, keep track of your case. So if somebody is traveling or somebody passes away, there's other people that are intimately familiar with your structure. But remember, they don't have your checkbook. Your checkbook's here in the underlying company. But these are deep pocket trustees that the beneficiaries are calling and saying, hey, we need a new car, we need this. How much more time do I have?
About 10, 11 minutes.
Excellent. So you want to build a relationship with those trustees. Just for fun, here's the United States, here's Cayman Islands, and that's manufactured because they would never show up. Those islands are really small. They'd never show up on the real map perspective. British Virgin Islands, U.S. Virgin Islands, Nevis and St. Kitts, Netherlands Antilles, so those are a bunch of tax havens. We use BVI for foreign companies. Most of you don't have a use for an offshore company, but we do have clients that do have an appropriate one, and that's a very good jurisdiction. This is the Isle of Man. Most people don't know about Isle of Man unless they drive a motorcycle. They know about the TTs, but it's kind of fun if you're in deposition and they're asking, where did you set up this trust? And you go, Cayman Islands, there's going to be a bunch of Snickers around the table. You can say Isle of Man, they go, where's that? That's in the UK. It's totally independent. It's never been a protectorate. It's never been like Bahamas or the British Virgin Islands. It's its own country. It's obviously very safe because it's in the middle between Scotland, Ireland, and England. Jersey and Guernsey, you've heard of. We've got a New Jersey in the United States named after this island here. So that's Guernsey and that's Jersey. They should be in France, right? But England had a war against them, and they never gave back the islands. So it's really part of the UK. There's really good professionals there. This is the Cook Islands. I had to put a little mark on it to show you where it is, but are there any bad actors around? No. They are a protectorate of New Zealand. The trustees have offices not only in the Cook Islands, but they have financial offices in Auckland. They're a good jurisdiction for this particular niche area that we're talking about. There's the asset protection team. As I said, we have 28 attorneys, and we're growing. It's great. But if you want that white paper, just say white. You don't have to write anything else. Just say white paper in the heading and send it to info at Tress Bidet. That's Elizabeth Tress, my partner. Unfortunately, she is not being able to join us tonight on the cruise. That's why I'm out of uniform, by the way, because we're going to go cruising tonight. Yeah. So what kind of questions? We probably have about 4 or 5 minutes left. Yes, Resurrection.
Yes. So when you open up in one offshore, when you set up in one offshore jurisdiction,
Hold on.
Thank you. I was saying, when you set up one company in one offshore jurisdiction, is there ever a need for you to have a client to set up in a different jurisdiction at a different time?
There could be, but the real thing is we're setting these up as dormant trusts. We're importing foreign law. We're using a Nevada Rockefeller. There's very few people. The 3520, been doing this for 35 years or something, has never triggered an audit. You have a foreign company, you have TD9s, 90, and some other forms, you're going to get an audit. It might not be every year, but every 5 years you're kind of signing up for that. So you need to have we're manufacturing in China, we have quality control in Singapore, we want that company. There are some companies that can go international, but that's not what we're promoting. We are the United States is the best tax haven and the safest place in the United States. I know a lot of people here disagree with that, but foreigners are trying to get their money into the United States. So we're using a Nevada company. And a Nevada company that's encumbering your, because so many big corporate America companies are in Nevada because of the tax haven it is. It looks normal to have Pine Tree Funding have a lien against your house. If you have a BVI company you better be a high flyer, and why you went to that kind of, even
You're
a
saying
stupid.
if the BVI company was the one encumbering your home,
Right.
that's going to raise eyebrows versus a Nevada pine tree lending, as you call
Yes,
it.
yes.
Although it's probably more, it'd be ponderosa pine.
Right, Rockefeller. But even a stupid lawyer is going to prick up their ears international. 80% of the time, adverse parties never find out about our structure. They don't ask the right questions. They're not expecting people to use a multi-state strategy. Rockefeller is just actually pretty dang amazing. Any other questions? Yes, Chuck?
Can we start with domestic and later move it to offshore?
Yes.
What was the question?
The question is, can we start with domestic and then move it offshore? Yes, just like that restaurateur that I was telling you about, we put provisions in it that decant it or move it offshore from trust to trust. Now, the importance of that, if we don't have that provision, you are the beneficiary. It doesn't have all the restrictions that you're putting in for your children's inheritance. The job of the trustee is to make you happy no matter what, even if it's giving it all back. The only thing is you can't give it if they're asking to get it back because they're under duress. They're having a lawsuit. So you can get it all back. And normally you'd have to get it all back and then start the international one. Now you're starting the statute of limitations over again. So that provision is really important, so you get the original date of your Nevada trust, even when you move it internationally. There's a question over here.
Tax that.
2 questions.
Watch out.
Uh-oh. How are you, Betty?
Hey, man, I'm going to be better. I just want a point of clarification from my own head. The statute of limitations refers to the time between when the trust is established and when it can possibly still be challenged.
Correct.
Okay, now one more. And 2 years in Nevada, but 0 offshore, Cook Island.
No, Cook Island still has a 2-year statute, complete bar, no matter what. It's a real statute. Here, the statute of limitations should be a drop-dead statute, but the statutes aren't the real law. The judges are here in the United States. So a judge can say, oh, there's circumstances that you've got an extra year to sue. Not in Nevada. Nevada supports their law. So there's a 2-year statute limitations here in the Nevada for domestic asset protection trust. Now, in the Cook Islands, not only do you have the 2-year complete bar, you have an effective bar at 1 year because the burden of proof is a criminal standard beyond a reasonable doubt. They'd have to have a video of you saying, Kevin, I want to do this because I owe somebody $3 million and I don't want to pay them. We wouldn't take you as a client with that, but that's the type of evidence that they would need. So only if they found out about it in the first year and paid a cash bond, which the plaintiff has to do, then it's a he said, she said. But we could set it up to right now and you get sued 4 months from now, we could drag it past that first year statute and probably past the second, if that's our goal.
Well, the other thing is, this is a lot of kind of almost like inside stuff. Are you guys keeping up with all this stuff? You got to be paying really close attention as Kevin's giving, he's sort of shorthanding some elements because he's a lawyer and he knows what he's talking about. And we're going, wait a minute, what does that mean?
Translate for me.
The other thing, if you haven't already mentioned it, is in these countries, you can re-domicile that thing somewhere else. So if there starts to be a problem and they go, oh, I think it's Cook Islands, all of a sudden that information can be moved to elsewhere.
Right. We put
They don't want to prosecute this because they can't ever catch it.
Yeah, we do put redomiciliary clauses in there, which is redomiciling, it's changing jurisdiction. But we can play those games. If it's really a malicious lawsuit of somebody with too much money that can spend all this, and then play games back. So have them go there, hire the barristers, go ahead and put the $150,000 cash bond, and by the time they finally spent all this time, it's not here. It moved, 4 months ago, 6 months ago to the Isle of Man. And then when they go there and hire the lawyers and do that, then it moves again. So you can play those games. Most of the time, it's such a slam dunk that we're going to say, if it's a vendetta, let's play games with them. But if not, let's stay here. You're going to win anyway.
Because it's not a trick. It's
Right.
all legal. It's all appropriate. The point is, if somebody really is going after something that's already this hard to get at, then there's a reason, you guys. There's a reason that, when you hear all these tax quotes, that, Warren Buffett's saying, my assistant is paying a higher tax rate than I am and it seems wrong or whatever. But the reality is, most rich people don't have money in their bank account, in their name. They have people that they're calling or they're borrowing money from some company. That's how it is.
Right.
I mean, they're not taking ordinary income.
Right.
They're making their money on capital gains or through any of the, 8 different ways you can take money.
Right.
And these structures aren't tricky. These structures are just things people that are not at a certain wealth level, they just don't know about
They
it.
don't have the exposure.
And you wonder why wealthy people can go through all kinds of risky things, take chances, have people coming at them all the time, but they don't lose their wealth. It's because it's not actually like in their pocket. You can't get it
Right.
because of the way they're structured. And even when we hear about Biden wants to raise ordinary income to 46% and all this, it's like rich people are just going, that's all political theater. This does not apply to me. We all go, oh, I don't ever want to pay that interest or that tax rate. But when you get up to that level, you won't be paying that tax rate, not because you wouldn't owe it if it was in your pocket, because it never made it to your pocket. Remember, own nothing, control everything. And that's what Kevin's talking about, the sort of the celestial end game, which is an irrevocable foreign trust that you just can't get to it.
Right. I think we have 2 more questions. Do we have time for 2, or should I take
Since
them?
I just took the people
Okay.
who are asking
Okay.
questions time. But does that little clarification,
Talk to me
is that
out there.
useful?
Talk to me out there.
Yeah.
Okay.
Okay, who wanted to
Very
raise their
good.
hand? Was there somebody, or are we done?
We have another question back here.
Okay, one
and
more
up
question, Robert.
Then you and me. Okay.
Make it a good one. This is the anchor.
Uh-oh, pressure.
The United States and Europe are entertaining an international tax on offshore accounts and
Correct.
right. How would that affect something like your protected assets offshore? Is
Yeah,
that gonna
it's
affect
not
any
going to
of that?
affect it all because this is tax neutral. It doesn't give you, there are strategies that can give you tax effect that most people don't have the right circumstances for, like employees that are international, et cetera. But internationally, the asset protection is still, all those same countries signed the Hague Convention. So it's
Criminal reciprocity, right? Isn't that
criminal-
mostly what the Hague Convention's about, is we're not going to harbor fugitives or their money?
correct. Yeah, if you're a gun runner or a big drug lord,
Or it's the Nazi hoard of
Right.
art or gold
Right.
sitting in a box
right,
in
that's
Switzerland.
what it's all about. Okay, thank you very much. I hope you
Give it up
learned
for
some
Kevin
fun-
Day.
Fun stuff, and we'll talk to you later.